As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually and, unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's February 23rd, 2024 free CLE webinar, Understanding Chapter 20 Rules Regulating the Florida Bar and the Application of Chapter 4 to FRPs. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all the questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. I will now turn it over to the FRP Enrichment CLE Co-Chair, Danielle Spradley.
Thank you. Good afternoon, everybody. Welcome again. The Florida Bar Registered Paralegal Enrichment Committee will have its annual meeting in June at the Signa by Hilton, Orlando, Bonnet Creek, and Waldorf Astoria. Everyone is invited to attend that meeting and the annual convention FRP Networking Mixer, which will be held on Friday, June 21st at the same location. We have sponsorship opportunities left for this event. If you have a sponsor opportunity or you want to sponsor, please contact Karen George at karen.george@csklegal.com for details. The next free webinar is in March from 2 p.m. to 1 p.m. Please watch your inboxes for the next date and registration. We invite all participants to visit our various social media platforms through Facebook, Instagram, X, LinkedIn. It is there you will find helpful tips and announcements of upcoming events and our monthly webinars. If anyone has a subject for a webinar you would like us to present, please reach out to Araceli Felix Mayorga at newcreation427@yahoo.com. Our speaker today is Juan Carlos Arias. Juan Carlos Arias was born in Puerto Rico and is the son of Cuban immigrants. He became a commissioned officer in the United States Army in 1993, and upon graduating from law school, served in the Judge Advocate General's Court, JAGC. During his military service, Juan Carlos attained the rank of captain and served as a legal assistant attorney, administrative law attorney, and military prosecutor. In addition to his military prosecutorial duties, he also served as a special assistant United States attorney responsible for the prosecution of civilians accused of committing crimes within the military installation. His awards and decorations include the Airborne Parachutist Badge, the Air Assault Badge, the Army Service Ribbon, the Army Achievement Medal, and the Army Commendation Medal. In 2002, Juan Carlos joined the State Attorney's Office for the 17th Judicial Circuit in Broward County and prosecuted cases in the Misdemeanor Trial Unit, Domestic Violence Unit, the Felony Trial Unit, and the Economic Crimes Unit. Juan Carlos became a bar counsel for the Florida Bar in December 2005. As bar counsel, he was one of 6 attorneys responsible for the investigation and prosecution of attorneys who violated the rules of professional conduct in the counties of Broward and Palm Beach. He has successfully argued before the Supreme Court of Florida. Juan Carlos represents clients statewide, including attorneys, Florida Bar applicants, nurses, and other licensed professionals before their professional boards. Juan Carlos frequently lectures in the area of law regulation at CLE programs sponsored by voluntary bar associations and private law firms. Thank you, Ms. Arias, for presenting today. I will now turn it over to you.
Thanks, Danielle, for giving a little bit background about me. And also thank you to Diana and, of course, Karen for the kind invitation. I always love being part of your CLEs because it's an open secret that paralegals are the backbone of law firms. So to have the opportunity to speak to, I believe there were over 1,000 registrants for this one. So hundreds of you all across the state and maybe the nation. Some of you may be doing CLEs, but working somewhere else. So welcome. And I will be talking today about Chapter 4 and Chapter 20. Obviously, Chapter 20 of the rules regulating the Florida bar deals with Florida registered paralegals. That is your chapter. And Chapter 4 of the rules deals with misconduct of attorneys. And there is a parallel on these two different chapters. And we're going to examine that today in the very short period that we have. So I'm going to be talking in general terms. You're welcome to type your questions on the comments. I believe that Diana is going to help me sort some of these questions at the end. I'll leave 5 to 10 minutes open at the end. Okay. So let's start with Chapter 20, the Florida Registered Paralegal Program. There are some requirements that paralegals in your position forget. And that's why we're doing this refresher course, because one of those rules that get some of you in trouble is the duty to update. And that is because, as with attorneys, when things happen in your professional life or in your personal life, some of these things may prompt your duty to inform the bar, okay, and also inform your supervising lawyers or employers. So it is very important that you understand that it is not, I'll wait for them to find out. There is indeed a duty to update that comes from this particular rule, which is 20-5.2. And what gives you kind of the content of and the context of what the requirement is there for. Here we have some of the issues that affect eligibility under 20-5 that obviously if it occurs during your term of registration, you may have to duty to notify. And let's look at some of these things that happen in life. These are things that happen to all of us. Hopefully not, but it does. A, suspended or disbarred, has resigned or been revoked in lieu of discipline from the practice of law in any state or jurisdiction. Some people, work as registered paralegals and they have licenses in other places and in Florida. And as you can see here, there's a duty if something happens at the level of discipline, you have an ongoing duty. B, convicted of a felony in a state or jurisdiction and has not had the person's civil rights restored. So a conviction of a felony does affect your practice as we know it. And of course, if your civil rights have not been restored, then that would be a requirement. So think about these things. Found to have engaged in the unlicensed or unauthorized practice of law in any jurisdiction within the last 7 years. As you know, we have a UPL side to bar regulation, and that's how the bar tries to keep out individuals that come to the state and perform lawyer duties, without supervision of lawyers and on their own. So that happens now and then. Has had the person's registration or license terminated or revoked for disciplinary reasons by a professional organization, court, disciplinary board, or agency in any jurisdiction. And if some of you have other jurisdictions where you're also a registered paralegal and there is discipline that comes out of that, you have a notice to you have a duty to report that. No longer primarily performing paralegal work. Okay, so if you're doing something other than what the actual license lets you do, that is something that may make you illegible and may be also something that you have to report. Fails to comply with prescribed continuing education, CLEs, clearly that will be an issue. And that will be an issue also if the time of registration ends and you didn't comply, and you haven't gotten any letters, again, you have an ongoing duty. And if you needed more time or there was an explanation for it, you need to be proactive, okay? Is providing services directly to the public as permitted by case laws. There are things that paralegals do without being the structure of not as a paralegal, but as an independent person that happens to be a paralegal that may be allowed. And that is something that may have an issue. And of course, you got to stay within the rules of what you can do, and engages in conduct involving dishonesty, fraud, deceit, or misrepresentation in the application or reapplication process. So you have to be truthful in this process. Your integrity is essential, and it's the core of the Florida Registered Paralegal Program, integrity. And it is also true under Chapter 4 for attorneys. Integrity encompasses all these values that are expected of individuals that are here to help people through the legal system. 20-6 talks about continuing legal education. In your case, a continual paralegal education, and the minimums are 33 hours of education every 3 years, and 5 hours of those 33 have to be dedicated to legal ethics or professionalism, and 3 hours of those must be in technology. I know that we had a change on the attorney side. The amount of hours per cycle have gone down. I got this info very recently, within 2 weeks, on the website, and for the paralegal, it's still 33 hours. I'm not sure if that's going to be adjusted or not, but I'll go with what it's being posted as of 2 weeks ago. And acceptable courses include courses approved by the Florida Bar, like this one, the National Association of Legal Assistants, NALA, and National Federation of Paralegal Associations, NFPA. Now, Rule 20-7 goes into the Code of Ethics and Responsibility. And this Code of Ethics, you will notice, really is parallel to the Chapter 4 rules for attorneys. So you're going to hear concepts here that are core to the practice of law by attorneys. Confidentiality and privilege, competence, conflict of interest, duty to report. All of these concepts are essential bedrock concepts of the practice of law, and it applies to you as part of the legal system. You are all part of a system that ensures that people's rights are protected. And this is not working for a Subway sandwich place. This is not working for Pizza Hut. You're a core player in the performance of legal duties. And it's very important that you understand that. Disclosure. Under A paralegal at your level shall disclose his or her status at the onset. Okay? Like attorneys have to say, I'm an attorney. You are bound to also communicate what is your title and credentials, okay, to the general public. Very important, and also to the clients, the lawyers, the court. Very important. That is your title, okay? Confidentiality and privilege. You have to preserve the confidence and secrets of clients. And as I tell attorneys when I teach CLEs, I tell you all, talking about your business outside the need to know people in your office is a bad habit. the clients that you're serving through your attorneys should not be a topic of conversation. And I go into some examples of cases. Usually I'm very tight for time today. The next time when I'm given 2 hours, I'll give you some examples, like the two paralegals that worked together forever. Then they went to different law firms. Then they had lunch together for a period of time and talk about clients. And then one client from one of them goes to the other, and then you have a conflict of interest. So that gives you a flavor. Some other time I'll take time to discuss that. But yes, not a good habit to be talking to people, even within your office. If you're doing your work in section A and other people work in section B and other people section C, you shouldn't be talking or gossiping in the water cooler about your A stuff, others on B stuff. Don't do that. It's just not professional. Need to know basis. That is the best advice I can give you. Appearances of impropriety. You should walk the extra mile to ensure that you are transparent in what you do and you're not being disrespectful and getting out of bounds. Look at the highlighted portion and see there. Paralegals should understand the attorney's rules of professional conduct. Yes, which are really in chapter 4, our next big topic. They are saying here that you need to know the rules that attorneys have to be bound by. So it's right there. B, prohibited conduct. Obviously, unlicensed practice of law is prohibited. Engage in the practice of law, on your own. Perform any of the duties that attorneys only may perform. Act in matters involving professional legal judgment. You're here to support. You're not here to take your own brain and do your own legal judgment for clients. Everything has to be channeled through the attorney, and anything you communicate needs to be communicated on behalf of an attorney. Engage in, encourage, or contribute to any act that could be constituted a UPL. Stay away from that. And obviously, establish attorney-client relationships. That will be unacceptable. Letter E, performance of services. You must perform exactly what you can for a client, and only assist, within those parameters. I think it's very clear. You will get that. The services performed by the paralegal do not require the exercise of independent professional legal judgment. The attorney is responsible for the client, maintains a direct relationship. Okay, and I teach this to attorneys all the time. It is okay to rely on paralegals, but you cannot delegate the ultimate responsibility of having a direct relationship with a client. So when I ask an attorney when they get a complaint about communication, this or that, when is the last time you spoke to the client? You had direct, well, that was like 2 years ago. Unacceptable. Unacceptable. I don't care how much responsibilities you as an attorney transfer to paralegals, you have to maintain a direct relationship. So if you can't do it, maybe you have too many cases. If you can't do it, maybe you have too many clients. If you can do it, maybe you should be doing some other business. That is not the legal practice of law. The attorney is responsible for maintains control of all client matters. The attorney supervises the paralegal. The attorney remains professionally responsible for all work on behalf of the client. And the services performed, supplement, merge with and become the attorney's work product. Okay, so obviously there's always going to be a prism, and that is the attorney. That's the essence of E. F, competence. You got to have competence. You need to know what you're doing. Conflict of interest applies. So you got to make sure that, especially when you're hired in a new firm, that all these conflicts are worked out, that you do not have knowledge of cases that are being handled by that firm, that you were on the opposite side. That happens. I do some screening for insurance companies that, they like to take some people from the economy, some attorneys and some paralegals, and bring them into the industry, and vice versa. And I help screen these paralegals, because believe it or not, the courts are all over the place as to how they treat potential conflicts with paralegals, and they truly treat paralegals and attorney kind of in the same way, because it's about the info that they have. It's not, oh, but she was only a paralegal. It is not like that in real life. So districts are all over the place on how they actually balance that, and of course, they always err on disqualification. So it's very important that everybody screen, and that you are aware that when you change jobs, if you were on the one side of a case and then you're in a firm that is handling another side, or the other side of that case, there is a potential issue. You got to flag that. Very important. And reporting, duty to report, like attorneys, if you know of obviously conduct that it breaks these rules, you have an ongoing duty to report it, and that's true for attorneys too. Revocation of registration, 20-8. So how does this work? There are district paralegal committees, at least one on every appellate district, and they are given the responsibility to process, to analyze, to study, to investigate, registrations for potential misconduct by FRPs. B, membership appointment. The committees are composed of no fewer than 3 individuals, and that must include one of you, a member, an FRP, and 2, a member of the Florida bar. That is, out of the minimum 3, you have to have that composition. They review the actions by the committee. They look at any issue that may be out there. The terms of service in these committees is 3 years, and they take an oath, obviously, and the member shall not exceed more than 6 years of continuous service. Okay, so there will be a timeout for some of these people. Continuing the rule, disqualification, no member of the district paralegal committee shall perform any district paralegal committee function when the member is related by blood or marriage to the complainant or the respondent, has a financial, business, property, or personal interest in the matter under consideration, with the complainant or with the respondent, on both sides, has a personal interest that could be affected by the outcome of the proceeding, is prejudiced or biased, either to the complainant or the respondent, and of course, removal. Any member may be removed from service by the designated reviewer of the committee and by the board. District paralegal committee meetings. District paralegal committee meetings should meet at regularly scheduled times, not less frequent than quarterly each year. Okay. Revocation and registration, 20-8.2. A registration certificate issued may be suspended or revoked for any of the following reasons. So we're getting here now to some of the nitty-gritty stuff. Conviction of a felony, we talked about that, or misdemeanor involving moral turpitude, dishonesty, or false statement. That second half of that is very tricky, because there are a lot of different levels where different agencies have their own definitions of moral turpitude. Okay, so this is like a catch-all kind of thing that you got to be very careful and seek advice, because a misdemeanor involving that, obviously, theft would be a classic, one. But there are some others, a burglary also, that may not sound like they are, but they may be considered. So this is a very dangerous area. It's easier if you just not commit any felony or misdemeanor. It's the easiest way to stay out of this analysis. Fraud, dishonesty, or corruption. Gross incompetence or unprofessional or unethical conduct. Willful, substantial, or repeated violation of any duty imposed by statute, rule, or order of the court. Fraud and or misrepresentation in obtaining or renewing the registration. non-compliance with CE's continuing education requirements, and non-payment of renewal fees, and violation of this code of conduct. How does the process work? It's a little bit like the bar complaint process for attorneys. All complaints are screened through the Florida bar, through a bar council that reviews it. The case may be closed at that point by the bar council if no misconduct is found, or it could be sent for a review by the committee. And the bar council may consult with the district paralegal committee chair to determine whether the conduct, if proven, will constitute a violation. And if the bar council and the district committee chair concur in finding that the case should be closed, the complaint may be closed without referral to the actual committee at large. If is referred to the district paralegal committee because both the chair and bar council think that there's something to it, then it's referred by the bar council and is filed with the appropriate district where the paralegal committee has jurisdiction over the individual. The notification of a violation goes out if the majority of the committee finds probable cause. They see that there's meat to the argument or the issue, then it's sent down, and that's how the process goes. And of course, the paralegal must inform their employer, their supervising attorney, that complaint is being investigated. So you have a duty to respond to notify your employer, your supervisor, and of course, you must file a written response within the 30 days that are given to you, so your side of the story can be presented. And then the committee reviews the complaint, and their finding of probable cause, any response filed, any other materials are pertinent, and the committee must decide whether to dismiss the proceeding or issue a proposed disposition. The investigation process of a complaint, as I said, it goes to the paralegal committee where they can take testimony. It may be very informal in nature. It's not, like you're in court, and they're not bound by the rules of evidence. This is important. So they can look at documents without, for example, some of you that do litigation support, without, having to have anybody testify to the records or anything like that. It's very formal in that way. And the rules of evidence don't work either for the process for attorneys, by the way. So the bar enters and reviews documents on their face. You don't need to have any authentication or anything like that. Taking testimony, again, they can hear from you and from witnesses if they choose to do so. It's all going to be under oath, so they can administer oaths. Rights and responsibilities of the respondent, that would be the paralegal, becomes the respondent. The respondent may be required to appear and produce evidence. And these committees have the power of subpoenaing too, so they can subpoena. Rights of complaining witnesses. The complaining witness is not a party to the investigation. May be granted the right to be present, but they're not running the show. Disposition 20-8.6. The committee could close the matter and find no violation. Close the matter with a letter of advice. This is similar to the world of attorneys. In the world of attorneys, these two, A and B, would be called non-disciplinary dispositions. So they don't have to say they had discipline if the case is closed or if they get a letter of advice. Require completion of a specified continuing CLE program could be required. Accept an affidavit from the paralegal acknowledging that the conduct surrounding the complaint was a violation, and that the person, the paralegal, will refrain. That would be a way of resolving it. It all depends on what kind of case it is, obviously, the allegations. Suspend the Florida registered paralegal for a period of time, not to exceed 1 year. Revoke the Florida registered paralegal's registration certificate, or deny any request for renewal down the road. So these are the dispositions available under the rule. So that's done. They made a recommendation at the committee level. What comes next? Well, Rule 20-8.6 give us some of the next levels of consideration of your case. Review by the designated reviewer. That is, this is the individual that oversees, and the bar system is for attorneys is similar. There are designated reviewers that are gatekeepers to make sure that things are done properly. A review by the disciplinary review committee shall review those district paralegal committee matters referred to it by the designated reviewer or the district paralegal committee. They may escalate this, and there's a review at that level. Board action on recommendations of the discipline, and that is after the review is done, the Board of Governors goes to the Board of Governors, and that's similar to the bar system. And they will, I have a little bottom page thing here, so disregard that, I apologize. But they can do many things. They can confirm it, reject it, amend it. So many things could happen at that level. I wanted to hone on one particular rule under Chapter 4, and that is the responsibility over paralegals. That is 4-5.3. This rule is very similar to two other preceding rules. One is 4-5.1 that deals with attorneys supervising other attorneys. And of course this one here. So you have the point one is the heads of the law firms, what they have to do, their duties. 4-5.2 is supervising attorneys, and then 4-5.3, this one is lawyers supervising non-lawyers. So that includes you paralegals and any other non-lawyer that works in a law firm. The important thing about Rule 4-5.3 under Rule 20, under Rule 4, and remember Chapter 4 is the disciplinary core chapter against attorneys. So Chapter 4-5.3 is the guidance to attorneys of what they have to do when they are supervising non-attorneys, which includes paralegals. This rule uses the title of non-lawyer assistants. So they don't specifically distinguish between a paralegal, legal assistant. They just call non-lawyer assistants, which opens the entire scope, because a non-lawyer assistant could be even the person that makes photocopies, the intern. So this is a very broad rule. And it basically says under B, supervisory responsibility, that the lawyer is responsible for the conduct of all the non-lawyers that work for them, under the rules. It's as simple as that. And in C, and by the way, the rule also says that they have the duty to ensure that their non-lawyer are knowledgeable on the rules, so they don't break them. So this is a core responsibility of an attorney, the training of his staff. And that's part of what I do, not only for nonprofit organizations like you, but I teach throughout the state law firms how I actually do the training, the ethics training that will make them compliant, because that is obviously a showing that they have taken the steps to ensure that their non-lawyers are trained on ethics. So they hire me and I teach them. And that way, if something goes wrong, obviously they can say, oh, we do this every year. We do this, every 2 years. Any new staff is trained. So this is an ongoing duty. You can't just say, oh, she's great doing paralegal stuff or non-lawyer stuff, and then forget about the other stuff, because this rule says that they must make reasonable efforts to ensure that the non-lawyer conduct is compatible with the professional obligations of the lawyer. And that is ethics. So you got to train your staff. You can't assume they know about competence, and they know about conflict of interest, and they know about all those things that are crucial in the practice. And of course, letter C, ultimate responsibility. Attorneys can delegate as much as they want, but at the end of the day, they are on the hook right here. That's why when I was bar counsel and I would get the defense, my paralegal, she miscalendar or he miscalendar, irrelevant, irrelevant. We cover a lot of stuff, very packed. So let's shoot some questions. I'm ready for it.
Okay, thank you. So the first question is, does subchapter 10-2 prohibit having a notary business outside of the law firm?
No, individuals can notarize. That is not an exclusive job of an attorney.
Okay.
There are responsibilities under that rule, as you all know. So you got to keep those records. There's also with the Department of State, or I think the governor's office is the one that oversees that. There are things you got to do, okay, and there are logs you got to keep, and all of that. And let me if I could, Diana, say something, because I've been involved in some notarization cases in the past. All of you who are notaries, remember that the individuals that are attesting, they have to be in front of you, okay? So you got to be very careful. I was a defense bar counsel for one of those big firms that got in trouble in the past because of foreclosure. And one of the elements that occurred in those prosecutions by the Florida bar had to do with notarizations that were not being made in person, and that tainted the process, and they became kind of mills in the sense of how these documents that were being submitted to the courts, were done, and it created a lot of problems. I've also seen variations of notaries not keeping that log and keeping track of what they notarize. It's very important that you take that very seriously. It's not a joke, and you could get in trouble, and I've seen that happen.
Okay. The second question is, how does the rule of attorney-client communication when the matter is short or limited, such as providing an estate plan, business formation, etc., where there is a limited scope of work?
Ask it again, please.
How does the rule of attorney-client communication when the matter is short or limited, such as providing an estate plan, a business formation, etc., where there is a limited scope of work?
No, I mean, the scope of work for communication, it's truly irrelevant, because what communication involves are many concepts that apply to whether the client was your client for a day or for 100 years. Communication is, one, answering questions from the client. Obviously, only attorneys can answer questions from the client on the essence of the matters. Procedural stuff, fine. So many attorneys delegate beyond the procedural stuff, and it happens out there that paralegals are really the ones that are answering and all that. It's just a bad habit. It's not the best practice. And I understand. I have over 100 cases at the Supreme Court level. I hundreds of investigations a year I'm involved in, certainly over 100. So I see all the parameters, those who do PI and they have massive cases, many clients. I see the estate planners. I see it all. I represent immigration. I understand exactly what kind of delegations are being done between attorneys and paralegals. Okay, so I'm not blind, uh, but the attorney has to maintain that direct contact. So where normally people get in trouble with communication is with the clients that become the nightmare clients that are very needy. And at some point, the paralegals and those in the office disconnect a little bit. They downgrade that client because it's the annoying client. Is the one that calls every day, is the one that shows up without appointments. And then that's where the danger zone starts because you stop calling the client back or emailing back on time. On time means what? Is there a rule that says when a client sends you an email or leaves you a voicemail, you have 24 hours? No, that doesn't exist. Okay. But is it reasonable 3 days? Is it reasonable 2 weeks? Is it reasonable a month? Probably not. So it is the responsibility of the attorney to make sure that these special clients do not fall through that crack of the indifference of the staff because they are annoying, meaning the clients. So those are the cases that attorneys need to truly identify. Those needy clients are the ones that most of the time file that complaint down the line, in my experience, because they're special and they need to be treated special. Sometimes the special clients need to be held and managed a little bit more closely. Okay. And I've heard attorneys and their paralegals when I'm trying to investigate and see how we're going to deal with that complaint. They say, well, that we don't do that for anyone. This is how we do it. Well, not every client is the same because human nature is different and varies. If you only practice like this, and this is the only thing we do, and this is what we do it, then you may be more prone to issues down the line because not every person is the same. And there's communication for Juan Arias, the client, that may be enough for Juan Arias, but may not be enough for Miss George as the client. So you got to know your clients, and I say it because I represent attorneys. They're so easy to. I mean, all your employers, they're so easy to deal with. Am I right? Imagine representing them in moments of crisis. Okay, not all my clients are the same. There's some that I have to zoom and go over a response that I've drafted because they need that. And I need to look at their eyes because I already know them. And there are others that I call, hey, John, send you the response. Juan is great. Thank you. Finally, done. John needs 20 seconds of my time. But then somebody else needs a whole Zoom for an hour. It happens. So to the person that asked that, you can't look at communication in a normal flat level. You got to look at it as a continuum. You got to identify points in the relationship, in the representation that will absolutely require communication from you, and those that need to have more communication because of their being special. And let me say something. Warning for all of you who communicate potential settlement offers, okay? It is very important, not only in PI, but in any area of the law, that when you seek and receive an approval of a settlement, that is reduced to writing. Okay? Is something I hate the most. and above me, the Florida bar, is yeah, she gave me the settlement offer. I called her, and now obviously the person is saying, no, that's not what I understood, whatever. Cover your behinds. You need to please take the time to document these things. These are very important points in any case, and they require reduction into writing. As discussed a few minutes ago over the phone, I explained to you that they're offering. I just did that this morning. I'm trying to resolve a case with the Florida bar, and the case is going to require some flaw ink oversight for several years. And I asked the bar counsel who told me the conditions over the phone, send me an email because I want to know what you're expecting on the flowing, what kind of intake review, what kind of recommendation. And then I send that to my client, got the approval. You got to make sure that you never leave any doors open when it comes to that, because that is great communication. So that every time you send an offer, that offer should have been approved by the client and documented. So you see all these different points in a case, in the progression of a case, should be communicated and should be reduced into writing. And that's in every type. It could be in trust and state. It could be in immigration, where there are times of no action because of the backlogs out there in that industry and that process, that governmental agency. And it is good to be in a cycle where you review your cases every 30 or 60 or 90 days, depending on what kind of immigration case or what kind of estate case. And then that cycle, there should be a communication from the paralegal or the attorney. So there should be some flags at different points. You all know those those points in the different areas you practice under attorneys where some communication should be required. And if there's a big gap of maybe 45 or 60 days, maybe the best practice is to have a, hey, by the way, nothing has happened on your case. It's just good business. It lets clients know that you're on top of it, that they haven't forgotten you. It's just, hey, it's a golden rule. You probably would like to hear that too if you were on their side, even though there's no activity and it's been already 45 days, 60, 90. That's up to the attorney to set. So I hope I was clear. Communication is communication, and it is all ruled by the necessities of the case and the stages where the case is.
The next question is, can you expound on Rule 20-7E1 regarding performance of services for FRPs that work in-house that do both traditional paralegal legal duties, but also business-related duties, such as claims or risk management?
Very interesting. We do know, and this is a fact, that non-lawyers are not supposed to be negotiating. Okay, so that is a hard rule, and that applies to everything. And I tell when I'm teaching ethics out there, especially to the personal injury world, I tell them, hey, that paralegal is not supposed to be putting up these offers and calling and negotiating. Hey, we'll take this or maybe that. Yeah, no, I mean that should not be happening. So we know that is a hard rule on everything. You cannot, negotiate. You can communicate. Mr. Arias has said that the client would take, 50,000 or whatever. But if they come back and they tell you 45, that's not 50. And I'm not comfortable when attorneys say, yeah, we'll take between 40 and 45. Call the adjuster. That's negotiating. A range is a negotiation. Stay away from that. So on that sense, paralegals on the business side, as you're saying, listen, any action that requires the independent application of a legal concept, which is called lawyering, is out of bound for a paralegal. It's as simple as that. You cannot as a non-lawyer, exercise any free decision or assumption based on law. It's as simple as that. Again, hard to put in a container. I get it. It's not contained like this. It's very fluid. I get it. But with experience, with the proper supervision, with a good relationship with the supervising attorneys, this happens, and it happens all the time throughout the nation. I mean, this is concept that applies to all attorneys, and you got to find that right balance of what you and that balance starts, by the way, sitting with the attorney and knowing what the attorney wants you to do, discuss the parameters of what not to do. It requires communication because not all attorneys are the same. Some may be more traditional, more conservative than others. So you need to know exactly what is expected of you by that employer. Okay. Don't assume that all attorneys see these rules the same and have the same containment barriers, because as many of you may know from having worked in this industry for a long time, not all attorneys are the same. So this is something that is set by that attorney, and of course, if you feel uncomfortable with the parameters, then that's a decision you got to make. But it starts with the attorney, okay? Because at the end of the line, as I always say to paralegals and attorneys, the paralegals are holding your license in their hands, okay? So you can go down burning like the Hindenburg if your paralegal, crosses lines. So this is serious business.
What can be done when an individual represents themselves as an FRP, but they are not?
Ooh, well, that's super problematic, and the bar, could absolutely go against that individual. And it's funny that this is asked because I just got involved in a case like that, but right, thank God that was a misunderstanding. But yeah, the bar council asked, "Hey, what about this individual? We don't. There was a change, a name change, and some time passed between the activity being complained of and the complaint being filed, and I was able to clarify it. So yeah, that you cannot do that, and you should report that."
Are FRPs, paralegals, or legal secretaries covered under their firm's professional liability insurance, or are they at personal risk?
Excellent question. They have all insurance policies. Not all insurance policies are the same. Okay. So I could not do a blanket statement as to that, but usually, okay, there is acts and omissions, and it does include the staff. I've seen policies that do, and in fact, I was part of a big case where the trust account was compromised, and it was the bookkeeper, paralegal that made the mistake, and that activity was covered under that policy. So I cannot say a blanket statement, but usually there is a coverage for that. And as you know, these days all these policies have become uh, more and more complicated because now you have all this hacking that is happening. So you have to add extra protections, um, for protection for somebody who takes your files, or steals your virtual office and this and that. So it's a jungle out there right now with all these different things that is offered. But usually, yes.
Okay, and here's one more question for you. So if a paralegal refers a case to another law firm and they offer a referral fee, can it be taken?
Wow. Good question. Attorneys are not allowed to split fees with non-lawyers. And even when they're splitting fees with lawyers, there are many rules that apply. Okay, it's a very complicated question that you ask, but the bottom line is no. If an attorney is paying a referral to a non-lawyer for that referral, that means that from that fee he or she is receiving, that person is receiving, the attorney, a piece is going to a non-lawyer. So the book answer is no, that cannot be done. Good question.
Thank you.
And let me say one more thing on that, because in the world of contingencies, contingency cases and all that, Florida doesn't have a referral fee, okay? Florida has a participation fee. That means that for an attorney that could receive a participation fee, not a referral fee, that attorney has to, one, be included in the retainer, so the client knows that that attorney is receiving a portion of the fee. It has to be in writing, okay? And the attorney needs to be responsible for the case and be there available for that client. So that's why it's called a participation fee. So in the world of contingency, we don't have referral fees. Your license is on the line. That's why listen, I practice regulation, professional regulation, as it was said at the beginning. I do bar defense, applicants to the bar, legals, anybody that has a license, nurses, real estate agents. That's what I do. That's my bread and butter. That's what I know. When I get somebody and I refer that person to a PI firm or whatever, I don't want a participation fee because I like to sleep at night. And just having money sent to me, which is great, from other people, it doesn't give me the peace of at night. I don't like my license being held by other people. So I just send the people, I don't want to know. I'm not part of that real estate case. I'm not part of, and the same when people refer me cases, I'm the guy that knows about what I'm doing. Okay. I'm not giving any fee to anyone. I take care of my. Okay. So that's how I do it. Because that participation requirement, it stresses me out. Okay. I don't want anybody doing criminal law with my name attached to it. And then something happens. And then guess what? We all get sued. Don't feel comfortable with it.
Thank you. Before I give the closing remarks from the bar, do you have any closing remarks?
I want to thank you all for the opportunity to again address all of you. This is you are at a level of professionalism that separates you from non-lawyer assistants. And I think you all cherish that, and you should uphold the highest values and always be mindful that you are holding not only a very important position in a law firm, but you're also holding the license of an attorney, and the way she that person makes a living, and that there are many consequences out of your acts or omissions. So take it seriously. I wish you the best in 2024 and be healthy. And thank you again for the invite.
Thank you, Mr. Arias, and thank you all for attending today's webinar. The course number for today's webinar is 8344. Again, the number is 8344. The webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit and 1 hour of ethics. Please self-report this course number in the member portal. You will receive an email tomorrow via Zoom outlining this information. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is a completely confidential and free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.